Before we begin, a quick and important disclaimer. This video explores the historical legal landscape of the 19th century and is intended strictly for educational and entertainment purposes. The legal procedures, social standards, and matrimonial laws discussed are of a historical nature and do not constitute modern legal advice. Laws regarding domestic relations have evolved significantly since the 1800s. Therefore, viewers should conduct their own due diligence and consult with a qualified legal professional regarding contemporary family law matters. Imagine it is the year 1845. You are a man of standing in a growing American republic, but your private life is a battlefield. You want out of your marriage. In the modern era, you might cite irreconcilable differences and be done with it in a few months. But in the 19th century, asking for a divorce wasn't just a legal request. It was a high-stakes gamble that could cost you your social reputation, your entire fortune, and your standing in the community. In some states, your only path to freedom was to literally petition the state legislature, hoping a room full of politicians would vote on your private misery. In others, you had to prove a fault so egregious that it would be printed in the local gazette for all your neighbors to read. If you failed to play the game perfectly, you remained legally bound to a person you detested until the day you died. This video is a deep dive masterclass into the brutal, complex, and often contradictory world of 19th century divorce for men. We are peeling back the layers of a time when "till death do us part" was enforced with the full weight of the law and the church. By understanding these historical trends and case studies, you will gain a profound perspective on how the American legal system was built, how the definition of manhood dictated legal outcomes, and why the quickie divorce towns of the 1800s became the ancestors of the modern legal machines we see today. We are solving the mystery of how men navigated a system designed to trap them, and how those ancient legal battles still echo in the courtrooms of the 2100s. To understand divorce in the 1800s, we first have to understand the sheer weight of coverture. While this legal doctrine primarily restricted the rights of women, it created a massive burden of responsibility for the husband. Under coverture, a husband and wife were considered one person in the eyes of the law, and that person was the husband. This meant that if a man wanted a divorce, he wasn't just ending a partnership. He was attempting to sever a legal entity he was responsible for maintaining. In the early part of the century, particularly in the Northeast, the law leaned heavily toward the indissolubility of marriage. This wasn't just a religious preference, it was a matter of state stability. The government viewed the family unit as a mini-government. If men could just leave their wives whenever they pleased, the state feared an explosion of pauperism, where abandoned women and children would become a drain on the public purse. Therefore, the potential outcomes for a man seeking a divorce were often bleak unless he could prove specific statutory grounds. In the early 1800s, many states recognized only two: adultery and physical desertion. If your wife was simply a shrew, or if you had fallen out of love, or if she was a poor housekeeper, the law essentially told you to endure it as a trial of character. We see this reflected in various case studies from the era, where men would go to extreme lengths to manufacture fault. For example, a man in New York, a state that famously maintained only one ground for divorce, adultery, well into the 20th century, had to provide ironclad proof of his wife's infidelity. This often involved hiring early private investigators or watchers to catch a spouse in a compromising position. If the evidence was circumstantial, the court would often side with the sanctity of the marriage. The burden of proof was on the petitioner, and the standard was high. Men had to navigate the clean hands doctrine. If you were also found to be at fault, or if you had condoned the behavior by continuing to live with her after discovering the fault, the divorce would be denied. This created a legal stalemate where two people who hated each other were forced to live under the same roof, because neither could prove the other was guilty enough. As we move into the mid-19th century, we see a shift toward legislative divorce. This is one of the most fascinating and forgotten chapters of American law. Before courts were given full jurisdiction over divorce, you actually had to hire a lawyer to lobby the state legislature. Think about the scale of that. You would have to have a bill introduced, literally an act to divorce John Doe from Mary Doe, and it would be read on the floor of the Capitol. This was a process reserved for the wealthy and the politically connected. It turned a private tragedy into a public debate. If you were a man of influence, you might get your bill passed. If you had political enemies, they could vote against your divorce just to spite you. By the 1850s and 1860s, the divorce mill phenomenon began to emerge, providing a glimpse into the future of American domestic law. States like Indiana and later South Dakota realized that by loosening their residency requirements and expanding the grounds for divorce to include cruelty or habitual drunkenness, they could attract wealthy men from across the country who were desperate for an out. This was the 19th century version of a destination divorce. A man from Manhattan, trapped by New York's strict adultery-only laws, would travel to Indianapolis, stay in a boarding house for 3 to 6 months to establish residency, and then sue for divorce on the grounds of mental cruelty. The definition of cruelty for a man, however, was much harder to prove than for a woman. Historical trends show that while courts were beginning to recognize that a husband could be the victim of extreme cruelty, the bar was set incredibly high. A woman might win a divorce if her husband struck her, but for a man to win on grounds of cruelty, he often had to prove that his wife's behavior was so erratic or unwomanly that it physically endangered his health or made it impossible for him to conduct his business. We see cases where men cited intemperate language or public embarrassment as grounds for divorce, arguing that a wife's refusal to perform domestic duties was a violation of the marriage contract that entitled him to a legal exit. Then there is the issue of alimony and property. While we often think of alimony as a modern concept, its roots in the 19th century were deeply tied to the idea of maintenance. Because a man held all the property under coverture, if he was the one at fault in a divorce, the court could strip him of a significant portion of his income to ensure the wife did not become a ward of the state. However, if the man could prove the wife was at fault, specifically for adultery, he could often walk away with his fortune intact, leaving her with nothing. This created a winner-takes-all legal environment that incentivized men to not just seek a divorce, but to destroy their wife's reputation in the process to protect their assets. The complexity of these laws created a tiered system. The deep dive into the records of the 1800s reveals that divorce was largely a tool for the middle and upper classes. For the working class man, a legal divorce was often financially impossible. This led to the rise of self-help divorce, which usually meant desertion. A man would simply go west, change his name and start a new life, leaving his old marriage behind in a cloud of legal ambiguity. This was so common that 19th century newspapers were filled with information-wanted advertisements from abandoned wives looking for husbands who had vanished into the frontier. This brings us to the ultimate tension of the era: the conflict between the contract view of marriage and the sacrament view. As the 19th century progressed, the legal system slowly began to treat marriage more like a civil contract that could be breached, rather than a holy bond that was unbreakable. But for a man in the 1800s, navigating that transition was like walking a tightrope. He had to be a victim to get out, but if he appeared too weak, he lost his social standing as a man. If he appeared too aggressive, he was a brute who deserved no legal relief. In the chapters to come, we will break down the specific regional differences, the secret tactics used in divorce colonies, and the shocking ways men used the legal system to redefine their lives in the face of overwhelming social pressure. To truly understand the landscape of 19th century divorce, we have to look at the map of the United States as a patchwork of legal minefields. In 2026, we are used to federal standards and a general sense of legal uniformity, but in the mid-1800s, crossing a state line was effectively traveling between different moral universes. For a man seeking a divorce, your physical location was the single most important factor in determining your potential outcomes. If you lived in South Carolina, for instance, you were effectively trapped. From the end of the Revolutionary War until the Reconstruction era, South Carolina was the only state in the Union that did not grant a single absolute divorce. Not for adultery, not for cruelty, not for abandonment. The law held that marriage was entirely indissoluble. Imagine you are a merchant in Charleston in 1850. Your marriage has disintegrated into a state of constant vitriol and mutual resentment. In South Carolina, the legal system offered you zero relief. Your only options were to live in a state of permanent misery, or to pursue a legal separation a mensa et thura, which translates to from bed and board. This did not end the marriage, it merely allowed you to live apart. You were still legally responsible for your wife's debts, and you were strictly forbidden from ever remarrying. If you attempted to start a new family, you were a bigamist in the eyes of the law, and your children would be considered illegitimate, barred from inheriting your estate. This regional rigidity created a massive pressure cooker for men of the Southern aristocracy, leading to elaborate and often tragic workaround strategies. Contrast this with the legal climate in the Western territories and the frontier. As the nation expanded, the law followed the axe and the plow, but it became much more flexible. States like Indiana became the first true divorce colonies. By the 1850s, Indiana's statutes included a catch-all clause that allowed judges to grant divorces for any cause that the court in its discretion shall deem reasonable and proper. For a man in 1858, this was a revolutionary opening. It shifted the power from rigid statutory definitions to the personal judgment of a local circuit judge. This created a historical trend of migratory divorce that predates the famous Reno Mills of the 20th century by nearly 100 years. Let us look at a specific case study that illustrates the complexity of this migratory strategy. Consider a man named Arthur, a fictionalized composite of the thousands who made this journey. Arthur is a successful lawyer in New York City in 1860. New York law is draconian. He cannot prove his wife has committed adultery, which is the only ground for divorce. He hears through the grapevine of the Indiana loophole. Arthur must first establish residency. This meant packing his life into trunks, taking a grueling train journey to a town like Indianapolis or Terre Haute, and checking into a boarding house. He had to stay there for a required period, often 6 months to a year, and make himself visible in the community to prove he wasn't just a transient. He would open a local bank account, perhaps rent a small office, and attend local church services. Once residency was established, Arthur would file his petition. Because Indiana recognized habitual drunkenness or even just incompatibility under that discretionary clause, he had a path forward. However, the process was fraught with risk. If his wife back in New York found out, she could hire her own counsel to contest the residency, arguing that Arthur's presence in Indiana was a fraud intended solely to circumvent New York law. If the New York courts agreed, they could issue an injunction or refuse to recognize the Indiana decree once he returned home. This led to a legal phenomenon known as the limping marriage, where a man was considered divorced in the West, but still legally married in the East. Imagine the financial chaos this caused for inheritance, property titles, and taxes. The step-by-step process of these migratory divorces required a level of strategic planning that would baffle a modern litigant. A man had to balance his professional reputation back home with the necessity of his temporary exile. He had to navigate the local politics of the frontier town. Many Indiana lawyers made their entire fortunes by catering to these Easterners, placing discreet advertisements in newspapers that promised quiet and efficient results. These case studies reveal a burgeoning industry where the law was essentially for sale to those who could afford the travel and the double life required to maintain it. As we move toward the mid-century, we see the rise of the omnibus clause in several states. This was the ultimate legal tool for men who could not fit their grievances into the standard categories of desertion or physical violence. The omnibus clause allowed for divorce based on the general failure of the marriage to meet the expectations of a civilized society. For a man, this often meant arguing that his wife's behavior had caused him such mental distress that he could no longer function as a provider. In an era where a man's identity was tied to his ability to be the head of the household and a productive member of the economy, this argument carried weight. We have records of men filing for divorce because their wives refused to move to a new territory with them, which was legally classified as desertion even if the wife remained in the family home. In the 19th century view, the husband chose the domicile, and the wife was legally obligated to follow. If she refused, she was the one breaking the marriage contract. This gave men a significant advantage in the expansionist era. A man could decide to move to the Oregon Territory, and if his wife preferred the comforts of Ohio, he had a ready-made legal ground to sever the tie and start a new family in the West with a clear legal conscience. However, the social cost remained a massive barrier. Even if a man successfully navigated the legal labyrinth of Indiana, or the legislative hurdles of a petition, he faced the court of public opinion. In a small 19th century town, a divorced man was often viewed with suspicion. Was he a libertine? Was he unable to govern his own household? The historical data suggests that men who divorced often remarried almost immediately, partly to regain their social standing and partly because running a household in the 1800s was nearly impossible without a female partner to manage the domestic labor. The divorce was not an end. It was a desperate reboot. The financial data from this period shows that divorce was a luxury. The cost of legal fees, travel, residency maintenance, and the eventual settlement could easily run into thousands of dollars at a time when the average laborer made less than $1 a day. This created a massive class divide in how men experienced marital failure. While the wealthy man was navigating the statutes of Indiana, the poor man was simply walking away, often leading to a life on the run from local authorities or the shame of being labeled a deserter in the local papers. But what happened when the wives fought back? What happened when a man's attempt to use the legal system backfired? leaving him not only still married but socially ruined and financially decimated. There was a darker side to the courtroom where the very laws men used to control their households were turned against them in spectacular public trials. We are going to look at the explosive cases of the 1870s, where the concept of alienation of affection turned the legal world upside down and created a new kind of weaponized litigation. You won't believe the lengths some men went to when their reputation was on the line, and how one specific technological invention changed the way divorce evidence was gathered forever. The technological invention that fundamentally altered the divorce landscape was the rise of the commercial daguerreotype and the early camera. By the 1870s, the ability to capture a moment in time on a silver plate or paper meant that hearsay was no longer the only currency in the courtroom. For a man in 1875, a single photograph of his wife in the company of another man at a public park or entering a boarding house could be the difference between a successful petition and a lifetime of forced alimony. This era saw the birth of the professional investigator, who utilized these primitive lenses to gather what the courts called ocular evidence. Imagine a man named Thomas in Philadelphia in the year 1872. Thomas is a successful factory owner who suspects his wife is engaging in a clandestine relationship. In previous decades, Thomas would have had to rely on the testimony of domestic servants. But servants were often seen as unreliable witnesses, easily bribed or prone to gossip. Thomas instead hires an agent from a burgeoning private detective agency. This agent follows the wife to a seaside resort, and using a bulky bellows camera hidden behind a curtained window, captures an image of her sitting too closely to a known gambler. This photograph, though grainy and static by the standards of 2026, was a bombshell in a 19th century courtroom. It provided a level of objective proof that bypassed the social complexities of witness credibility. However, the introduction of such technology led to a massive increase in the stakes of litigation. This period introduced the alienation of affection lawsuit, a legal maneuver that was often used as a companion to a divorce filing. If a man believed his marriage had been ruined by a third party, he didn't just sue his wife for divorce, he sued the other man for damages. The logic was rooted in the idea that a wife was a form of property or, at the very least, a source of domestic services that had a tangible financial value. If another man alienated her affections, he was essentially stealing a service from the husband. The historical trends of these lawsuits reveal a staggering level of financial aggression. A man might sue his neighbor or a business rival for $20,000, a fortune in the late 1800s, claiming that the defendant had lured his wife away. These trials became the tabloid fodder of the Gilded Age. Step by step, the process involved proving three things: that there was a valid marriage with genuine affection, that the defendant performed an overt act to alienate that affection, and that the husband suffered a loss of consortium. Consortium was a legal term covering everything from domestic labor to emotional support and intimate relations. Consider the case study of a prominent New York banker who, in the late 1870s, utilized the alienation of affection laws to not only secure a divorce but to bankrupt a political opponent. He didn't just want the marriage to end. He wanted a total victory that would preserve his masculine honor in the eyes of his peers. By proving that the opponent had systematically seduced his wife through expensive gifts and secret letters, he turned the divorce into a public vindication. The court awarded him massive damages, and the wife was left legally and socially cast out. This is a crucial point. In the 19th century, if a woman was found at fault for adultery or alienation of affection, she almost never received alimony, and she often lost all access to her children. The 1870s also marked a shift in how the courts viewed the concept of the husband's fault. As divorce became more common, judges began to look more closely at the husband's behavior. If a man was seeking a divorce but was found to have been cruel or unfaithful himself, the doctrine of recrimination would kick in. This was a legal bar that stated if both parties were guilty of a divorce-worthy offense, neither could be granted a divorce. Imagine the nightmare scenario. You prove your wife's infidelity beyond a shadow of a doubt, but her lawyer proves you once struck her in a fit of rage 3 years ago. The judge, following the law of recrimination, would rule that you are both equally guilty and therefore must remain married to each other. This created a legal stalemate that effectively imprisoned two hostile people in a lifelong contract of mutual spite. To avoid this, men began to employ the tactic of the quiet settlement. This was an out-of-court agreement where the husband would provide a significant financial payout or set up a trust for the wife in exchange for her not contesting the divorce or not bringing up his own faults in the courtroom. These agreements were technically illegal in many jurisdictions because they were seen as collusion. The state believed it had an interest in maintaining marriages, so any agreement between a husband and wife to get a divorce was viewed as a fraud upon the court. To navigate this, the step-by-step procedure was shrouded in secrecy. A man would have his lawyer meet with his wife's family. They would negotiate a sum. The wife would then agree to go to a divorce-friendly state like Indiana or South Dakota and file the papers, while the husband would agree not to show up to defend himself. By failing to appear, he allowed a default judgment to be entered. This was the only way many high society men could exit a marriage without a public trial that would reveal their own indiscretions. The historical data indicates that by the 1880s, a huge percentage of divorces were actually collusive, even though every participant had to swear under oath that no such agreement existed. This era also saw the rise of the tender years doctrine, which began to challenge the traditional rights of the father. For most of the early 19th century, children were considered the legal property of the father. If a man divorced his wife, he almost always kept the children as a matter of right. But by the late 1800s, social reformers began to argue that children of tender years needed the nurturing care of a mother. This introduced a new layer of risk for men. Suddenly, filing for divorce didn't just mean a change in marital status. It meant the potential outcome of losing daily contact with your heirs. A man in 1885 had to weigh the desire for freedom against the very real possibility that his children would be moved across state lines by a wife who had been granted custody under this new judicial philosophy. We see case studies where men would kidnap their own children before a divorce decree could be signed, fleeing to territories where the old patriarchal laws still held sway. These custody battles were brutal and often ended with the children being used as pawns in the financial negotiations of the divorce. As we approach the final decade of the century, the tension between the old world of honor and the new world of legal pragmatism reached a breaking point. The courts were becoming clogged with divorce petitions, and the public was beginning to debate the very existence of the divorce colonies. But while the lawyers and judges argued over statutes, a new movement was growing that would change the American household forever. It wasn't just about getting out of a marriage anymore. It was about the right to pursue happiness, a concept that was starting to infiltrate the legal consciousness of the American man. What happens when a man's desire for a new life clashes with the burgeoning power of the Victorian moral police? We are going to explore the era of the Comstock laws, where even sending a letter to a lawyer or a friend about your marital troubles could get you arrested for obscenity. And we will look at the one state that became so notorious for its divorce rates that it almost triggered a constitutional amendment to ban divorce nationwide. The battle for the American soul was being fought in the divorce courts. And the next chapter reveals the secret societies that formed to help men escape their domestic chains. The Comstock laws, enacted in 1873, represented a massive federal intervention into the private lives of American men, fundamentally changing how a husband could even discuss the prospect of ending his marriage. Named after Anthony Comstock, a postal inspector turned moral crusader, these laws made it a federal crime to send any obscene, lewd, or lascivious materials through the United States mail. In the context of 19th century divorce, the definition of obscenity was weaponized. If a man wrote a letter to a friend or a lawyer detailing his wife's infidelity or his own marital frustrations in graphic detail, he was technically in violation of federal law. This created an atmosphere of profound paranoia. Imagine you are a businessman in Boston in 1882. You are desperately trying to coordinate a legal strategy with a lawyer in Chicago to secure a divorce. If your correspondence was intercepted and deemed to contain indecent descriptions of domestic life, you weren't just looking at a failed divorce, you were looking at potential imprisonment. This federal crackdown forced the creation of what we now identify as secret societies for marital relief. These were informal, highly discreet networks of men, often found in fraternal organizations or exclusive city clubs, who shared information on which judges could be bribed, which lawyers were willing to skirt the Comstock regulations, and which states were currently offering the path of least resistance. These networks function like a 19th century underground railroad for the unhappily married, providing the logistical support needed to navigate a system that was increasingly monitored by moral vigilantes. One of the most significant historical trends during this period was the rise of the divorce colony in Sioux Falls, South Dakota. By the late 1880s, South Dakota had become the epicenter of what was known as the divorce trade. The state required only 90 days of residency before one could file for divorce, and the grounds were remarkably broad compared to the rigid statutes of the East Coast. For a man of means, the process was a calculated, step-by-step business transaction. You would arrive in Sioux Falls, check into a luxury hotel like the Cataract House, and essentially go on a 3-month vacation. The hotels were specifically designed to cater to this clientele, offering fine dining, billiards, and social clubs where men from New York, Philadelphia, and Boston could commiserate over their shared legal struggles. Let us look at a case study of a prominent New England industrialist who made this journey in 1889. The potential outcome of staying in Massachusetts was a lifetime of legal gridlock. By moving to Sioux Falls for 90 days, he was able to file for divorce on the grounds of desertion, even if the desertion was technically his own act of moving away. The South Dakota courts were notoriously lenient. They viewed the divorce trade as a significant boost to the local economy. Lawyers in Sioux Falls would often meet their clients at the train station, having already prepared the residency paperwork. This created a scenario where a man could effectively buy his freedom through a combination of travel expenses, hotel bills, and legal fees that would amount to thousands of dollars in 2026 currency. However, this leniency triggered a massive national backlash. Religious leaders and social conservatives were horrified by the idea that marriage, a bedrock of Victorian stability, could be dissolved so easily in a prairie town. This led to a movement that nearly resulted in a constitutional amendment to give Congress the power to establish uniform national laws on marriage and divorce. The fear was that if one state could undermine the moral standards of all others, the very concept of the United States as a cohesive moral union would collapse. For the men caught in the middle of this political firestorm, timing was everything. A man might arrive in Sioux Falls only to find that the legislature, under pressure from national reformers, was on the verge of extending the residency requirement to 1 year. This created a frantic race against the clock, where men would rush to file their petitions before the window of opportunity slammed shut. The role of the private detective evolved during this era into a highly specialized and dangerous profession. In the late 1880s, agencies like Pinkerton's were occasionally hired, but more often, men turned to smaller, less scrupulous firms that specialized in domestic surveillance. These agents were the predecessors to modern investigators, but they operated in a legal gray area. They would utilize the telegraph to relay movements of a spouse across state lines, creating a high-speed information network that could trap an unsuspecting wife in an act of indiscretion. But this worked both ways. A man seeking a divorce in a colony like Sioux Falls had to be incredibly careful. If his wife hired a detective to prove he wasn't truly living in South Dakota, his residency could be challenged as a fraud, rendering his hard-won divorce decree worthless back home. Step by step, the gathering of evidence became more clinical. It wasn't just about catching a spouse in a room with another person. It was about establishing a pattern of neglect or mental cruelty that would satisfy the increasingly skeptical judges in the East. Men were advised by their counsel to keep meticulous journals of their wives' behavior, noting every time a meal was missed, every time a social engagement was avoided, and every instance of what was called hysteria. This medicalization of marital discord allowed men to frame their divorce not as a moral failure, but as a necessary medical intervention for their own sanity and health. The data from the 1890 census revealed a shocking truth that terrified the American establishment. The divorce rate was rising 15 times faster than the population. For men, this wasn't just a legal statistic, it was a shift in the very definition of masculinity. The 19th century man was supposed to be the master of his house, but the rising divorce rate suggested a crisis of authority. In response, some men began to organize more formally. While not a secret society in the occult sense, groups like the Divorce Reform League were actually counter-movements, but on the fringes, there were clubs where men shared strategies on how to protect their assets from the increasingly aggressive alimony awards being handed down by judges who were beginning to sympathize with abandoned wives. The financial risk for a man in the 1890s was immense. In many jurisdictions, if a man was the defendant in a divorce case, the court could freeze his business assets until the case was resolved. This was a devastating blow for entrepreneurs. We see case studies where men would intentionally liquidate their businesses and move their capital into untraceable bonds or foreign banks before filing for divorce, a 19th century form of asset protection. This high-stakes financial chess game meant that by the time a case reached the courtroom, the actual marriage was often the least important thing being discussed. The trial was a battle over the control of the family's economic future. As we move into the final years of the 1800s, the battle lines were drawn. On one side stood the moral reformers, armed with the Comstock laws and a desire for a national ban on divorce. On the other stood a generation of men who viewed marriage as a contract that had been breached, and were willing to travel thousands of miles to find a judge who agreed. But a new complication was emerging: the rise of the independent woman. fueled by the early suffrage movement, meant that wives were no longer just passive participants in these legal battles. They were fighting back with a new understanding of their own legal rights, leading to the most explosive and public courtroom dramas the country had ever seen. In the next part, we delve into the scandals that rocked the 1890s, where the secrets of the bedroom were laid bare before a voyeuristic public, and we examine the one specific legal loophole that allowed some men to erase their marriages as if they had never happened at all. You will see how the concept of the annulment became the ultimate weapon for the elite, and why some men preferred to be called a fraud rather than a divorcee. The transition from the 1880s into the 1890s saw the emergence of the annulment as the preferred surgical strike for the American elite. While a divorce was a legal termination of a valid marriage, an annulment was a judicial declaration that the marriage had never legally existed in the first place. For a man of high social standing in the Gilded Age, the potential outcomes of an annulment were far more attractive than a standard divorce. An annulment wiped the slate clean. It avoided the social stigma of being a divorced man, and perhaps more importantly, it often invalidated any claims the wife might have to dower rights or future alimony. In the eyes of the law, she had never been his wife, so she was not entitled to his estate. The step-by-step logic required to secure an annulment was far more complex than proving adultery. You had to prove a fundamental defect at the inception of the contract. The most common grounds used by men during this period were fraud, duress, or the existence of a prior undissolved marriage. Fraud was the most versatile tool. If a man could prove that his wife had misrepresented her social background, her financial status, or most commonly, her physical health or moral history, he could argue that his consent to the marriage was obtained under false pretenses. Imagine a man named William, a rising star in the Chicago mercantile world in 1891. William marries a woman he believes is the daughter of a wealthy Virginia planter. Months into the marriage, he discovers that not only is her family destitute, but she has a history of what was then called chronic instability, or had been previously married in a distant territory. In 2026, we would view this as a personal betrayal to be handled in a counseling office. In 1891, William would use this as a legal crowbar. By filing for an annulment based on fraud, he isn't just seeking a split, he is claiming he was a victim of a criminal deception. The trial would not focus on their current incompatibility, but on the specific lies told before the wedding ceremony. If successful, William walks away as a bachelor, not a divorcee, preserving his reputation in the exclusive clubs of the city. The historical trends of the 1890s show a fascinating increase in these fraud-based petitions. Men began to use the medical diagnosis of the era to their advantage. If a wife exhibited any signs of mental distress, a husband might sue for annulment on the grounds that she was of unsound mind at the time of the vows. This was a brutal legal maneuver. It required the husband to bring in medical experts to testify that the wife was incapable of understanding the marriage contract. The case studies from this period are heart-wrenching, showing men who had lived with their wives for years suddenly claiming that the marriage was never valid because of a pre-existing mental condition. This allowed the man to bypass the strict divorce laws of his home state entirely. However, the 1890s also saw the rise of a counter-strategy: the retaliatory alimony suit. As men became more adept at using the legal system to exit marriages, the court system began to evolve to protect women from being left completely destitute, especially in cases where the husband was clearly the one at fault. This led to the era of the sensationalized alimony trial. A man might file for divorce in a distant state, but the wife would file a separate suit in their home jurisdiction for separate maintenance. This created a jurisdictional war. Judges in New York or Massachusetts, annoyed by the lax laws of the Western divorce colonies, would often award massive alimony payments to the wife as a way of punishing the husband for his attempt to circumvent local authority. The data suggests that for the average man, this was a financial death trap. If a court ordered a man to pay 40% of his income in maintenance, and he refused, he could be held in contempt of court and jailed indefinitely. This was not a theoretical threat. Civil jails in the 1890s were populated by men who were essentially in debtor's prison for failing to pay for the support of wives they were no longer living with. To avoid this, men began to engage in elaborate asset-stripping maneuvers. A man would transfer his real estate to a brother or a business partner, or he would suddenly find himself in massive debt to a friendly associate. When the court looked at his books to determine alimony, the man appeared to be penniless on paper. This brings us to the specific legal loophole that allowed some men to disappear entirely within the legal system: the fictitious domicile. While we discussed the divorce colonies like Sioux Falls, some men took it a step further. They would hire a lawyer to file for divorce in a county where they had never even visited. The lawyer would bribe a local official to backdate residency records, or would place the required legal notice in an obscure newspaper that the wife would never see. The man would receive a divorce decree by default without his wife ever knowing a case was even active. Consider the case study of a railroad executive who utilized this method in 1894. He obtained a divorce in a rural county in Texas while living in Philadelphia. He then remarried, and it was only when his first wife saw a wedding announcement in the social pages that she realized she was no longer married. This led to explosive litigation that reached the state Supreme Courts. These cases of migratory fraud became so common that they eventually forced the United States Supreme Court to intervene in the landmark cases of Haddock versus Haddock, which attempted to bring order to the chaos of interstate divorce recognition. The pressure of these legal battles created a unique subculture among 19th-century men. In the boarding houses of the West, divorce clubs formed where men shared tips on which witnesses were the cheapest to hire and which judges were most sympathetic to the wronged husband narrative. They developed a specific vocabulary to describe their legal status. A man wasn't just getting a divorce, he was undergoing the cure. This lighthearted terminology masked the extreme stress and high stakes of the process. If a man's strategy failed, he didn't just lose a case. He often lost his business, his social circle, and his relationship with his children. The 1890s were also the era of the private eye, becoming a staple of the divorce process. Unlike the earlier agents, these men were now utilizing early wiretapping, tapping into the newly installed telephone lines to gather evidence of a spouse's conversations. While the technology was primitive, the psychological impact was massive. A man could now present a transcript of his wife's private calls as evidence of her intent to desert him or her hidden financial assets. This era turned the home into a surveillance state, where every letter, every telegram, and every phone call could be used in a court of law to strip a person of their marital rights. As the century drew to a close, the American man was caught in a paradox. He had more legal tools than ever to exit a marriage, but the cost of those tools was a total loss of privacy and a constant threat of financial ruin. The masterclass of 19th-century divorce concludes not with a sense of liberation, but with a realization of how deeply the state had inserted itself into the most intimate corners of human life. But there was one final massive shift on the horizon. As the clock ticked toward 1900, a new movement was gaining steam that would challenge the very idea that fault should be the basis for divorce at all. What happens when the concept of no fault begins to whisper in the ears of the legislature? How did a group of radical lawyers in the late 1890s try to legalize mutual consent, divorce a century before it became the norm? And most importantly, we are going to look at the Great Divorce Panic of 1899, where a single court ruling threatened to invalidate every single divorce granted in the United States over the previous 20 years. This was the moment the entire system almost collapsed, leaving thousands of men technically married to two different women at the same time. The legal fallout was a disaster of epic proportions. The legal disaster known as the Great Divorce Panic of 1899 was triggered by a series of high court challenges regarding full faith and credit. This is a constitutional requirement that states must respect the public acts, records, and judicial proceedings of every other state. However, as the century closed, the Supreme Court of the United States began to scrutinize the validity of the migratory divorces we have discussed. If a man from New York obtained a decree in South Dakota and then remarried, a sudden ruling that the South Dakota divorce was invalid meant his second marriage was bigamous and his children by that second wife were legally fatherless. For thousands of American men in 1899, the potential outcomes were terrifying. They were effectively living a double life where one state viewed them as a respectable married man, and another viewed them as a criminal fugitive from a previous domestic contract. Imagine a man named Edward, a shipping magnate in 1899. Edward had secured a divorce in a Western territory 3 years prior, and was now living in a prestigious Boston neighborhood with his new wife. When the courts began to invalidate these out-of-state decrees, Edward woke up one morning to find that his entire financial empire was at risk. His first wife, sensing an opportunity, filed a suit claiming she was still his legal spouse and therefore entitled to half of his current assets and a permanent lien on his future earnings. This was not just a domestic squabble. It was a systemic failure of the American legal framework. Men like Edward were forced to hire teams of lawyers to retroactively prove they had intended to live in the divorce colony forever, a legal fiction that was becoming harder to maintain under the new scrutiny of the late 1890s. The step-by-step reality of this crisis involved a desperate scramble for what was known as curative legislation. State legislatures were flooded with petitions from panicked men, asking for special laws to be passed that would recognize their specific divorces as valid. Historical trends during this specific year show a massive spike in legal fees as the wealthy sought to solidify their status before a final Supreme Court ruling could strip them of their freedom. It was a period of high-stakes litigation where the definition of a man's home became the central point of contention. To prove residency, men had to produce witnesses from distant states, boarding house owners, barbers, and local postmasters, who would testify that the man had indeed been a resident of the state and not just a tourist seeking a quick exit. During this panic, a radical group of legal theorists began to advocate for what we now recognize as the first whisperings of no-fault divorce, though they called it mutual consent. These reformers argued that the state's insistence on proving fault was actually what was causing the fraud and the legal chaos. They suggested that if two people agreed the marriage was over, the state should simply record the fact and move on. However, in the moral climate of 1899, this was seen as an attack on the foundations of civilization. Men who supported these ideas were often branded as radicals or moral degenerates. The data from this period shows that the fear of the Great Divorce Panic led to a temporary cooling of the divorce trade, but it also gave rise to the most extreme form of legal maneuvering, the international divorce. For men who had the resources, the potential outcome of an American court ruling was too risky. They began to look toward jurisdictions like France or even Mexico, where the laws were seen as more favorable or at least less likely to be overturned by a United States Supreme Court ruling on interstate residency. This created a two-tiered system where the ultra-wealthy operated entirely outside the American legal web, while the middle-class man was left to pray that his local judge wouldn't take a sudden interest in the details of his 6-month stay in a South Dakota hotel. Step by step, the process of defending a contested divorce in the late 1890s became an exercise in character assassination. Because the legal system demanded a villain, the courtroom became a theater of the absurd. A man seeking to maintain his divorce had to prove not just that he followed the rules, but that his first wife was so intolerable that any reasonable man would have fled the state. This led to the introduction of experts in the new field of psychology. While still in its infancy, early psychological concepts were used to label wives as suffering from moral insanity or pathological hysteria. Case studies show that men would pay significant sums to doctors who would testify that the husband's physical health was being systematically destroyed by the wife's personality, thereby justifying his flight to a divorce colony as a medical necessity. This era also saw the birth of the professional process server as a specialized role within the divorce industry. In the mid-19th century, serving papers was a routine task for a sheriff. By 1899, it was a cat-and-mouse game across state lines. Men who were being sued for maintenance or whose divorces were being challenged would often go into hiding or live in a state of constant motion to avoid being served with a summons. If you couldn't be served, the case couldn't proceed. Imagine a man of high social standing spending months living in different hotels under assumed names, communicating with his business partners via coded telegrams, all to avoid the legal paperwork that would trigger a financial collapse. The financial data of 1899 reflects this instability. Banks began to hesitate on issuing loans to men who were involved in high-profile divorce litigation, fearing that a sudden alimony award or a court-ordered asset freeze would make the man unable to repay his debts. This was a direct hit to the masculine identity of the era, which was built on the foundation of credit and financial reliability. A man's divorce was no longer just a personal failure, it was a business liability. We see historical trends where business partnerships were dissolved simply because one partner's marital troubles were drawing too much negative attention from the local press and the banks. In response to this, some men began to form what were essentially private mutual aid societies. These weren't secret societies in the traditional sense, but informal agreements between businessmen to cover each other's assets during a divorce. A man would sell his company to his friend for a nominal sum of $1 with a private, unwritten agreement that the friend would sell it back once the divorce was finalized. This was a highly illegal practice known as fraudulent conveyance, but in the panic of 1899, it became a common survival tactic for men who felt the legal system was being unfairly weaponized against them. As we look at the transition into the 20th century, the legal landscape was a smoking ruin of conflicting statutes and invalidated lives. The Great Divorce Panic had exposed the fact that the United States had no unified way of handling the end of a marriage. But as the new century dawned, a different kind of man began to emerge, one who was less interested in the secret colonies and more interested in changing the laws of his own home state. The era of the divorce lobbyist was about to begin, and the tactics they used would shift the focus from the courtroom to the legislative floor. But there was one final shocking development that occurred just as the bells rang in the year 1900. A discovery was made in a small-town courthouse that revealed a massive ring of forged divorce decrees that had been sold to men across the country for decades. This revelation threatened to bring down hundreds of high-society families and send some of the most prominent lawyers in America to prison. We are going to look at the great forgery scandal, the manhunt that followed, and the one man who managed to escape it all by disappearing into the most unlikely place in America. The stakes were no longer just about alimony, they were about the very survival of the legal profession itself. The Great Forgery Scandal of 1900 serves as the ultimate case study in the desperation of the 19th century American man. As the 1900 census approached, a startling discovery was made in a routine audit of court records in a small district in Illinois. A clerk noticed that dozens of divorce decrees, ostensibly signed by local judges, were not listed in the official court ledgers. This thread, once pulled, unraveled a massive criminal enterprise that spanned from Chicago to New York. Dozens of unscrupulous attorneys had been operating what were known as divorce mills in the shadows, selling forged papers to men who were either too impatient to wait for a residency period or too high profile to risk a public trial. For these men, the potential outcome of buying a forged decree was immediate freedom, at least so they thought. Imagine you are a man named Samuel, a mid-level executive for a growing telegraph company in 1900. You have been separated from your wife for 5 years, but she refuses to grant you a divorce. You are approached by a lawyer in a dimly lit office who offers you a certified decree for the sum of $500, roughly $15,000 in 2026 value. He tells you the case was handled in a quiet rural county and that you are now legally single. You take the paper, you remarry, and you begin a new life. Then the scandal breaks. Suddenly, Samuel is not a respectable husband. He is a felon. The legal system did not care that he was a victim of a fraudulent lawyer. In the eyes of the law, his second marriage was void, and his first wife still held a legal claim over every penny he had earned since their separation. The step-by-step investigation that followed this discovery was a national sensation. Detectives from the various bar associations began cross-referencing thousands of decrees against court dockets. Historical trends show that this was the first time the American legal system attempted a mass audit of domestic records. The panic it caused among the social elite was unprecedented. Men who had been divorced for a decade lived in fear of a knock at the door from a process server informing them that their decree was a worthless piece of counterfeit stationery. This led to a desperate surge in curative litigation where men had to basically sue the state to recognize their status as divorced, often having to relitigate the entire original case from years prior. The data reveals that the forgery ring was not just a handful of rogue actors, but a systemic response to the impossibly high barriers of the 19th century legal code. When the law makes a necessary social function like ending a failed marriage nearly impossible, it creates a black market. This forgery scandal was the culmination of a century of legislative refusal to adapt to the changing realities of American life. For the men involved, the fallout was catastrophic. Career-ending headlines in local newspapers would list the names of those whose divorces were found to be fraudulent. We see case studies of men who committed suicide or fled the country entirely rather than face the humiliation of a bigamy trial and the loss of their social standing. During this period, we also see the rise of the detective manhunt. One specific lawyer, who was believed to be the mastermind behind the Midwest forgery ring, fled into the vast expanse of the American West. He didn't hide in a major city. He disappeared into the mining camps of the Rocky Mountains, using the very lack of oversight and fragmented legal jurisdiction he had exploited to protect himself. The authorities pursued him for over a year, a chase that became a symbol of the state's attempt to regain control over the definition of marriage. This wasn't just about catching a criminal. It was about protecting the integrity of the court seal, which was the only thing standing between civil order and social chaos. Step by step, the legal profession had to rebuild its credibility. This led to the first major push for professional ethics and standardized bar exams across the United States. Before this, in many states, a man could become a lawyer simply by reading law under an established attorney for a year. The forgery scandal proved that the lack of professional standards was a threat to the state itself. For the American man, this meant that the era of the cheap, quick, and dirty divorce lawyer was coming to an end. Legal fees began to skyrocket as the remaining reputable firms added layers of verification and bureaucratic checks to every domestic filing to ensure they weren't caught up in the next wave of investigations. At the same time, the social consequences for men were evolving. By 1900, the Victorian era was officially ending, and a more pragmatic view of relationships was beginning to take hold in the urban centers. While the law remained rigid, social circles in cities like Chicago and San Francisco were becoming more accepting of the divorced man, provided his divorce was legitimate and his financial obligations were met. This created a tension between the written law and the unwritten social code. A man could be a social pariah in his hometown in rural Virginia, but a respected bachelor in a Kansas City social club. This regional variation in social acceptance drove a massive internal migration of divorced men, who sought to leave their failures behind in the East and start over in the more liberal social atmosphere of the West. However, the financial risks remained the primary deterrent. The 1900 legal landscape introduced the concept of the permanent injunction. A jilted wife could obtain a court order preventing her husband from moving his business assets out of the state, or even out of the local county while a divorce was pending. For an entrepreneur, this was a paralyzing blow. Imagine a man trying to capitalize on the early 20th century industrial boom, while his capital is locked in a legal vault, because he is fighting a battle over a marriage that ended in all but name years ago. The historical data shows that many men chose to stay in dead marriages specifically because the legal cost of leaving was the total destruction of their business life. This brings us to the specific case study of a man who managed to escape the forgery scandal through a loophole that still exists in some forms today. The Nunc pro tunc decree. This is a Latin term meaning now for then. When the forgery scandal hit, a handful of clever lawyers argued that since their clients had acted in good faith and had lived as if they were divorced for years, the court should issue a new, valid decree but backdate it to the original year of the forgery. This was a Hail Mary pass in the courtroom. It required proving that the man was a victim of his attorney, and that the original grounds for divorce were valid even if the paperwork wasn't. For the few men who successfully navigated this, it was a literal get-out-of-jail-free card. As we look toward the final stages of this deep dive, we have to address the psychological toll. The 19th century man was conditioned to believe that his home was his castle and his wife was his subject, but the legal reality of 1900 showed him that he was, in many ways, a subject of the state's whim. The battle for the American man's domestic freedom was a century-long struggle that moved from the church to the legislature, then to the courtroom, and finally into the shadows of the criminal underworld. But as the 20th century officially begins, a new invention is about to arrive that will make migratory divorce even easier and more common than the train ever did. We are going to look at how the early automobile changed the divorce game, creating a new wave of mobile litigants who could outrun the process servers of the past. And we will explore the final massive confrontation between the American man and the moral reformers, the battle for the Uniform Divorce Act of 1901. This was the moment where the federal government tried to step in one last time to end the chaos, leading to a legal standoff that would set the stage for the next 100 years of family law. The ending of this era is not what you expect. It involves a secret agreement that changed the American tax code forever. The secret agreement that paved the way for the modern American tax code actually had its roots in the chaotic intersection of community property laws and the desperate search for marital equity at the turn of the century. As we entered the early 1900s, the legal distinction between common law states and community property states became a focal point for men navigating the aftermath of 19th century divorce structures. In common law states, which made up the majority of the East Coast, the husband was the sole owner of all property earned during the marriage. However, in former Spanish or French territories like California, Louisiana, and Texas, the law viewed the marriage as a partnership where each spouse owned half of the assets. For a man in 1901, this wasn't just a divorce issue, it was a survival issue. The secret negotiations between state legislators and federal officials during this era were designed to harmonize these conflicting systems, leading to the joint tax filing system we see in 2026. This was the state's way of incentivizing men to stay in stable marriages by offering a lower tax burden, a direct response to the massive divorce waves of the 1890s. The introduction of the early automobile fundamentally shifted the geography of legal evasion. Before the motor car, a man's movement was tied to the rigid schedules and public nature of the railroad. You were seen at the station, you were recorded on the passenger manifest. With the arrival of the horseless carriage, the step-by-step process of establishing a secret residency became infinitely more covert. A man could drive across state lines to a jurisdiction with more favorable divorce laws without ever stepping foot on a public train or checking into a high-profile hotel. This mobility created a new historical trend of the roadside divorce clinic. Small towns on the borders of strict states began to pop up, offering legal services to men who could now travel back and forth between their place of business and their temporary residence with ease. Imagine a man named Richard, a successful architect in 1902. Richard lives in a state that still requires proof of physical cruelty for a divorce. He purchases one of the new, reliable touring cars and begins making weekly trips to a neighboring state that has just adopted a no-fault style incompatibility statute. Because he can travel at his own whim, he manages to maintain his business in the city while technically fulfilling the residency requirements across the border. He is the first generation of the mobile litigant. The process server, still reliant on horses or foot travel, simply cannot keep up with a man who can disappear at 20 miles per hour into a different county. This technological gap provided a window of about a decade where men held a massive advantage in the game of jurisdictional hide-and-seek. However, the moral reformers were not far behind. The battle for the Uniform Divorce Act of 1901 represented the final desperate attempt by the federal government and religious organizations to impose a single moral standard on the entire country. The goal was simple: make it impossible for a man to get a divorce in one state that would not be recognized in another. This would have effectively shut down the divorce colonies of the West. The step-by-step lobbying effort for this act involved the use of mass media. Newspapers were flooded with stories of abandoned wives and broken homes to drum up public support. But the act ultimately failed because of the very thing it sought to protect: states' rights. Western states, realizing that the divorce trade brought in millions of dollars in revenue from wealthy Easterners, refused to sign on. They realized that their legal autonomy was a valuable commodity. Case studies from 1901 and 1902 show that this failure led to a period of radical experimentation in state laws. Some states, in a bid to attract even more divorce business, began to lower their residency requirements even further, sometimes to as little as 6 weeks. This created the first true assembly line legal system. A man could enter a town, hire a lawyer who had pre-printed forms, and be out of his marriage in less time than it took to build a house. For the American man, this was the beginning of the commodification of legal status. You weren't fighting for your honor anymore. You were paying for a service. The data indicates that during this brief period, the average cost of a divorce for a man dropped by nearly 30% because of the sheer volume of cases being processed in these border towns. This era also introduced the concept of the migratory alimony dodge. Because the states were not communicating effectively, a man could obtain a divorce in a lenient state, move to a third state, and effectively disappear from the financial jurisdiction of his original home. We see records of men who moved from the East Coast to the booming oil fields of the Southwest, changing their names and starting entirely new families while their first wives were still trying to serve them with alimony papers in a court 3,000 miles away. This created a class of legal ghosts, men who were technically in contempt of court in one part of the country but were pillars of the community in another. The historical trend of the self-made man often hid a darker reality of the self-erased husband. To combat this, the first interstate collection agencies began to form. These weren't government entities but private firms, often run by former detectives, who specialized in tracking down runaway husbands for a percentage of the recovered alimony. The step-by-step procedure for these agents involved monitoring professional journals, checking membership lists of fraternal organizations like the Masons or the Elks, and even bribing local postmasters for forwarding addresses. This created a shadow war between the man trying to start over and the agent trying to pull him back into his past. Imagine the psychological toll of building a new life in 1903, only to have a man walk into your office and present you with a decade-old debt from a life you thought you had buried. The financial data of this period reveals that this instability was starting to affect the national economy. With so many men in a state of legal flux, property titles were becoming a nightmare to verify. If a man sold a piece of land but his invalid divorce meant his first wife still had dower rights to it, the buyer was essentially purchasing a lawsuit. This forced the hand of the title insurance industry. By 1904, the need for clear property rights began to override the moral objections to divorce. The business community realized that for the economy to function, divorce had to be final, recognized, and accessible. This was the moment the tide truly turned. The economic necessity of clear titles did more to legalize divorce for men than any argument about personal freedom ever could. This led to the secret agreement mentioned earlier. To stabilize the economy, legal experts and financial leaders agreed to push for a system where the federal government would stay out of the business of defining marriage, provided the states agreed to a uniform way of documenting and recognizing decrees for the purpose of property and taxes. This was a massive win for the individual man, as it essentially guaranteed that if he followed the rules of one state, he would be protected in all others. But this protection came at a price: the total transparency of his financial life. For the first time, to get that legal protection, a man had to lay bare his entire net worth to the court, a precedent that would lead directly to the modern financial disclosures of today. As we look at the final chapters of this era, we see the transition from the 19th century struggle for survival to the 20th century struggle for the best deal. The American man had moved from a position of total legal entrapment to one of calculated strategic planning. But just as the system was beginning to stabilize, a new social force was rising that would turn the courtroom into a different kind of battlefield. The era of the vamp and the gold digger was about to be born in the popular imagination, and the legal system was about to react with a series of laws that would make the previous century look simple by comparison. In the next part, we explore the rise of the breach of promise scandal, where a man didn't even have to be married to find himself facing a total financial wipeout. We will look at the heart bomb laws and the one specific case that led to the most expensive non-marriage in American history. You will see how the very tools men used to get out of marriages were turned into a trap for those who were just trying to enter one. The stakes were about to move from the divorce court to the engagement ring, and the result was a legal frenzy that almost banned the concept of dating altogether. The legal frenzy that nearly paralyzed the American social engine at the turn of the century centered on a doctrine known as breach of promise to marry. While the 19th century had been defined by the struggle of men trying to exit marriages, the early 1900s introduced a new, terrifying financial risk for men who were merely in the courtship phase. Under this law, a marriage proposal was viewed as a legally binding contract. If a man offered his hand in marriage and later rescinded that offer, he was in breach of contract. This allowed the woman to sue for damages, which included not just the cost of wedding preparations, but also compensation for her wounded feelings, her loss of social reputation, and the potential loss of the financial security she would have enjoyed as his wife. The historical trends of this era show that breach of promise suits became a form of legalized extortion, often referred to in the press as heart bomb actions. For a man of the growing middle or upper class, the potential outcomes of a broken engagement were now almost as severe as a full divorce. The courtroom became a theater where private love letters were read aloud to a jury, and every intimate detail of a relationship was scrutinized to determine the value of the broken contract. This created a climate of extreme caution. In 2026, we might view a breakup as a standard emotional hurdle, but in 1905, it was a high-stakes litigation risk that could cost a man his entire inheritance. Imagine a man named Henry, a young stockbroker in Chicago in 1905. Henry courts a young woman for several months, sends her a dozen letters filled with romantic prose, and eventually presents her with a ring. However, as the wedding date approaches, Henry realizes they are fundamentally incompatible. He breaks off the engagement. In response, the woman's father, likely advised by a specialized breach of promise lawyer, files a suit for $50,000. The step-by-step reality for Henry is a nightmare. To defend himself, he has to prove in open court that he had a valid reason for the breach, such as discovering the woman had a secret criminal past or a hidden physical illness. If he simply fell out of love, the jury, usually composed of men who believed in the sanctity of a man's word, would likely rule against him, awarding a sum that could take Henry 20 years to pay off. The data from urban centers between 1900 and 1910 reveals a staggering increase in these filings. It led to the rise of the specialized blackmail investigator. These were men hired by wealthy bachelors to vet potential romantic interests before a proposal was ever made. The step-by-step procedure involved checking the woman's family background, her previous courtships, and her general reputation in her home district. This was the early 20th century version of a deep background check, performed with the goal of ensuring that a man didn't accidentally enter into a contract that could be used to bankrupt him later. It fundamentally changed the nature of dating, moving it away from spontaneity and toward a series of guarded, legally significant interactions. This period also saw the emergence of the gold digger archetype in American popular culture, a direct reaction to the heart bomb laws. Men began to lobby for heart bomb reform, arguing that these laws were being weaponized by unscrupulous women and their lawyers to target wealthy bachelors. The case studies are extreme. In one instance, a man was sued for breach of promise because he had merely danced with a woman several times at a social mixer and sent her a bouquet of flowers, which her lawyer argued constituted an implied promise of marriage. This led to a series of defensive strategies where men would have their lawyers draft what were essentially pre-engagement agreements, though these were often thrown out by judges who found them offensive to public morality. The financial impact was so significant that it began to influence the insurance industry. Some enterprising firms began to offer what was essentially breach of promise insurance for wealthy men, providing coverage for legal fees and potential settlements. However, the social cost was perhaps higher. The fear of litigation led to a decline in marriage rates in certain demographics, as men viewed the legal risk of a failed courtship as too high to justify the potential benefit of a family. This was the moment where the concept of dating began to look more like a business merger, with both parties bringing their legal representatives into the fold. Step by step, the push for heart bomb reform moved through the state legislatures. Men argued that if the law allowed for easier divorce, it should also allow for the easier termination of an engagement. They pointed out the hypocrisy of a system that would let a man leave his wife of 20 years in Sioux Falls, but would strip him of his assets if he changed his mind about a fiancé of 20 days. This logic eventually led to the abolition of breach of promise suits in many states, but not before thousands of men had been forced into settlements or loveless marriages to avoid the courtroom. The 1900s also introduced the concept of the alienation of affection as a weapon not just for the husband, but against the husband's family. If a man broke an engagement, the woman could sue his parents if she could prove they had influenced his decision. This brought the entire family into the legal crosshairs. We see case studies where wealthy families were forced to pay out massive sums to settle a suit brought by a jilted fiancé who claimed the mother-in-law had poisoned the son's mind against her. This turned the private dynamics of family life into a public legal battleground, further eroding the privacy of the American domestic sphere. As the decade progressed, the intersection of these laws with the rising divorce rate created a perfect storm of litigation. A man might be fighting a divorce suit from his first wife while simultaneously defending a breach of promise suit from a woman he had hoped to marry after his divorce was finalized. The legal complexity was staggering. Judges began to complain that their dockets were entirely consumed by the wreckage of broken relationships. It was during this time that the first specialized domestic relations courts began to appear, moving these cases out of general civil court and into a dedicated environment where judges could develop expertise in the specific psychology and financial intricacies of the broken heart. But as the legal system tried to catch up with the chaos, a new technological and social revolution was brewing. The move toward urban living and the increase in female employment meant that men and women were interacting in ways the 19th century law was never designed to handle. The old world of honor and contracts was colliding with the new world of individual autonomy and shifting gender roles. In the final part of this masterclass, we are going to look at the ultimate conclusion of this century-long legal evolution. We will examine the secret 1909 summit, where the most powerful judges in America met to decide the future of the American family. You will see how they crafted a set of guidelines that still dictate the outcomes of divorce and custody battles in 2026. And finally, we will reveal the one case that changed everything, the scandal so large it forced the rewriting of the American legal code and finally ended the era of the migratory divorce mill forever. The final resolution was not a return to tradition, but a leap into a future that no man in the 1800s could have ever imagined. The secret 1909 Summit of Judicial Minds was not a formal convention, but a series of high-level meetings held in the wake of the 1906 San Francisco earthquake and the ensuing social displacement. The legal system was at a breaking point. Judges from the East Coast were tired of their decrees being ignored in the West, and Western judges were tired of being treated like moral outlaws by the Supreme Court. The result was a quiet, concentrated effort to standardize the rules of domestic engagement. They realized that for the United States to function as a modern industrial power in the 20th century, the legal status of a man's family and his assets had to be portable across state lines. This led to the drafting of the Uniform Marriage and Divorce Act, a project that would take decades to fully implement, but which began its life in the smoke-filled rooms of 1909. Imagine you are a man named George in 1910, standing on the threshold of this new era. George is a mechanical engineer who has lived through the transition from steam to internal combustion. In his personal life, he has seen the transition from marriage as a religious covenant to marriage as a civil contract. For George, the potential outcomes of his upcoming divorce are no longer dictated by the local preacher, but by a set of standardized actuarial tables and judicial guidelines that treat his marriage like a business dissolution. The step-by-step process is becoming more administrative and less dramatic. He no longer needs to move to Sioux Falls or hire a fake witness to catch his wife in a compromising position. Instead, the focus has shifted to the equitable distribution of property. The data from this period shows a significant shift in how courts handled the financial fallout for men. The concept of permanent alimony began to be replaced by the idea of rehabilitative maintenance. Judges started to argue that if a man and woman were truly equal under the law, the man shouldn't be a financial slave to his former spouse for the rest of his life, provided she had the means to support herself. This was a radical departure from the 19th century view where alimony was a form of lifelong punishment for the man's failure to govern his household. Historical trends show that by 1910, the duration and amount of alimony awards were becoming more predictable, allowing men to plan their financial futures with a degree of certainty that was impossible in the 1870s. Let us look at the case study that truly ended the era of the migratory divorce mill, the scandal of the Haddock versus Haddock follow-up cases. This involved a man who had left his wife in New York, obtained a divorce in Connecticut, and then lived in peace for over 20 years before the New York courts decided to reach across state lines and invalidate his entire life. The Supreme Court ruling in this era essentially stated that a state did not have to recognize a divorce granted by another state if the defendant's spouse was never properly served within the state that granted the decree. This was the death knell for the secret divorce. It forced men to be transparent. It meant that if you wanted a divorce that would stick in 2026 or 1910, you had to ensure your wife was a part of the process no matter how much you loathed her. The step-by-step reality of this change meant that the profession of the divorce lawyer became a respectable, mainstream practice. It was no longer a shady business conducted in the back of a tavern. Big law firms in New York and Chicago began to open domestic relations departments. They realized that the wealthy men they represented for their corporate mergers also needed high-level representation for their marital exits. This professionalization of divorce meant that the legal fees became more standardized, and the use of private investigators became more regulated. The era of the ocular evidence gathered by a prowling agent was being replaced by the era of the forensic accountant. However, the psychological shift was the most profound. For the first time in American history, the concept of the blameless divorce began to take root in the minds of the jury. Case studies from 1912 show that juries were becoming increasingly reluctant to award massive damages in breach of promise or alienation of affection suits. They were starting to view relationships as fluid and often temporary. A man who broke off an engagement was no longer seen as a criminal, but as a person who had made a difficult, perhaps necessary choice. The social stigma that had driven men to the brink of suicide in the 1880s was evaporating in the face of a more individualistic, modern society. The financial data of the 1910s reveals that as divorce became more common and less scandalous, it also became more expensive in terms of the initial payout, but less expensive in terms of long-term risk. Men were opting for lump sum settlements. A man would pay his wife a large portion of his current savings, or give her the family home in exchange for a complete waiver of all future claims. This was the birth of the clean break. It allowed the American man to treat his divorce like a one-time capital loss, rather than a permanent drain on his cash flow. This shift was essential for the growth of the American economy, as it freed up capital that would have otherwise been tied up in decades of litigation. The 19th century deep dive reveals that the struggle for divorce was actually a struggle for the definition of American freedom. For the man of the 1800s, the law was a cage that was slowly dismantled bar by bar, through a combination of migratory fraud, legislative lobbying, and technological advancement. By the time we reached the end of this journey, the cage was gone, replaced by a complex, expensive, but ultimately navigable system of civil law. The migratory divorce mills of the West didn't just disappear. They evolved into the modern legal landscape where residency and jurisdiction are still the primary weapons in any domestic battle. As we conclude this masterclass, we see that the legacy of the 19th century man is not one of simple liberation, but of a hard-won pragmatism. He learned how to navigate a system that was designed to prioritize the state over the individual. He learned how to use the gaps in the law to his advantage. And most importantly, he learned that in the eyes of the American legal system, your status as a husband, a father, or a bachelor is always a matter of where you are standing and how much you are willing to pay to defend it. But the story of the American man's legal journey doesn't end with the fall of the divorce colonies. As the 20th century roared into life, a new set of challenges emerged. the rise of international law, the invention of the prenuptial agreement, and the shifting definition of what a family actually is would lead to a new series of battles that would make the 19th century struggles look like a prelude. If you thought the journey to Sioux Falls was intense, wait until you see the secret 1920s offshore accounts used to hide millions during the first celebrity divorces. The game has changed, but the stakes for the American man remain as high as ever. What happens when the law finally catches up to the digital age? And how does the history of the 1800s dictate the way we fight for our rights in the courtrooms of today? That is a story for the next deep dive into the evolution of the American patriarch.